seems this. Can you hear me clearly?
We hear you very clearly.
Okay. So let me start this and see if it's going to work. Good morning, sir. You used a bundle on Friday. Could I ask you to turn to page 76 of that bundle?
Chair, can we just remind Mr. Rulofse that Colonel Rulofse that he is under oath. He took the oath on Friday and he remains under oath.
Mr. Rulofse, you are being reminded that you are
Can you?
under oath.
Yes, I am reminded, thank you.
Can you hear me, Ms. Bauer? Can you hear me?
I can. There appears to be some background noise and static, so I can hear you, but not very clearly.
I can hear you, and very clearly.
I think there's just been an improvement now.
Okay. Mr. Rulofse, can you say something again? Let's see if Ms. Bauer can hear you.
Good morning, Advocate Bauer.
Right, that's much better. I can hear.
Okay. Okay, that sounds good.
Colonel,
Start.
Right, Colonel Rulofse, there's a bundle that you referred to on Friday. Can you turn to page 76 of that bundle?
Yes, I have.
Right. It appears to be a confirmatory affidavit. Can you tell the inquiry how that came about?
Madam Chair, I was in Cape Town at the time, and I received a email from a Mr. Sibila Metsa, who is a state from the State Attorney's Office or the State Prosecutors at Justice, requiring me to sign this affidavit, this confirmatory affidavit. I refused to sign the confirmatory affidavit because I didn't have any affidavit that I had to confirm. Then a while later, I think it was on the same day or the second day, or the day after, I received a draft affidavit from Mr. Sibila Metsa, sending me a draft affidavit from Advocate Mokgoro. I then said I cannot sign the confirmatory affidavit because I don't have the signed one. I don't know what Mr. Mokgoro is actually going to say at the end of the day. I then also had various issues with the draft affidavit that was sent to me because I felt that there were inaccuracies in there and that the full picture was not placed before court. And I drafted an email to that effect to him. I cannot find that specific email. I have found the email that was sent to me by Advocate Mokgoro, inquiring as to why don't I deal just with the facts or just with the issues at hand.
Mr. Rulofse, I think we may be having some difficulties while Advocate Bauer sees if she can hear you again. Let me ask you this. Are the emails, can you go to page 74 of your bundle? Are those the emails that you referred to?
That's correct, Madam
So
Chair.
that's page 74 and 75, is that right?
That is correct.
Okay. And what are those emails about?
Well, the first email is one that I sent to, well, let me put it differently. As I said, I cannot find my email. But what I do have here is the email that was sent to Mr. Sibilabetsa by Advocate Mokgoro regarding my queries, questions regarding his draft affidavit. And then there is my email responding to Advocate Mokgoro regarding what he has just mentioned in his previous email.
Thank you. Let's just see if Advocate Bauer is back online before our next question.
We can't hear you, Ms. Bauer. Okay.
Try again, Nazreen.
Sorry.
Sorry,
Try
Chair.
again.
Can we just ask her to try again?
Try again, Ms.
Okay,
Bauer.
can we try this again? Do you hear me now?
Yeah, we hear you clearly.
Okay. And the upshot of it is, Colonel Roloff, so you never did sign a confirmatory affidavit, is that correct?
That's correct, Madam Chair.
Right. Now, I want to take you to a report dated 23 February 2015. Have you got that report in front of you? It is in the Dropbox at J158. It is a report prepared by Advocates Rousseau and Lowe on February 2015. Rousseau, Lowe, Broughton and Zikali. Have you got?
I have it, Madam Chair.
Have you had an opportunity to peruse this report?
Yes, I did.
Right. I want to take you specifically to a few of the paragraphs in that report. Maybe what we need to do is, it is, as one sees from the, as one sees in the introductory paragraphs, it is a report that was prepared post the SCA judgment, which set aside the decision to withdraw the fraud and corruption charges against Messrs. Mluli and Barnard. Is that correct?
That's correct, Madam Chair.
And that effectively the conclusion is reached that the charges and proceedings are automatically reinstated for the authorities to deal with in paragraph 3.
That's correct, Madam Chair.
Yes, right. Can I take you specifically to paragraphs 21, 22 of the memorandum?
Yes, I'm there.
And we see that Advocates Lowe and Rousseau details in paragraph 21 that it must be borne in mind that the original case had very little to do with the Secret Service account. Do you agree with that?
That is correct, Madam Chair.
And in the second sentence they say it would in fact be possible to prove the fraud and corruption committed by the accused in relation to the BMW transactions without any reference to the SCA or any documents in custody of CI, which I understand to be Crime Intelligence, and UTE. Correct?
That
obtained from third parties, inter alia, Leo Heise, BMW Finance and Atlantis Motors were sufficient to prove the original case against Mluli and Barnard.
That is correct.
And so effectively they agreed with the evidence which you tendered before this inquiry last week.
That is correct, Madam Chair.
Then I just want you to turn to paragraph 80. Sorry, let me just find the correct paragraph. Very essentially under paragraph N deal with the issue of a concealment of a conflict of interest. They also deal with the acknowledgement of debt in this memorandum in paragraph 85 onwards. Do you see that?
That's correct, Madam Chair.
And then if you look in the section dealing from paragraph 87 onwards, they deal in detail with the charges that was preferred. Do you agree with that?
That is correct, Madam Chair.
And then in section P, they deal with additional events which leads to further charges.
That is correct, Madam Chair.
Right. In Q, they set out the state of the investigation and on page 21. And in the next two sections on page 23 and 24, they deal with other matters related, which goes beyond what was before, which was the case in December 2011, correct?
That is correct, Madam Chair.
Okay. Thank you. I've got no, by the way, before I do this, let me just double check. I've got no further evidence indirect for Colonel Roelofse, and anything else would then arise in reply. Thank you. And I'm indebted to my colleagues for allowing this.
Thank you, Ms. Bauer. We will give Mr. Majabu opportunity to cross-examine. Thank you.
Good morning, Judge and co-panelists, colleagues. Captain Colonel Roelofse, for avoidance of doubt, may I confirm with you that the supplementary evidence that you've just been led on this morning bears no reference to Advocate Jiba?
That is correct, Madam Chair.
That being the case, Chair, I've got no further questions to this witness.
Thank you. Mr. Ramawele.
Thank you, Just. Thank you,
I got it right this time, ne?
Yes,
Thank you.
yes, you got it right.
Thank you.
And thank you, Justice. Good morning, Colonel Roelofse.
Good morning, sir.
How many years of experience do you have in the police service, obviously?
Sir, as I testified earlier, I joined the South African Police Service in 1986. I then joined the DSO in 2000, came back to the South African Police Service in 2009.
Remind us, by the way, what is the DSO?
It was the previous, known as the Scorpions.
Scorpions.
That is correct, yeah.
And how many years did you spend as a detective? Or were you a detective?
Yes, I am. Approximately since 1995, 1996, thereabouts.
You were a detective?
Yes, as from that point onwards, I was involved in investigation of cases, yes.
1995 until today, it will be how many years? Plus minus.
Now you're asking me to do mathematics.
Yeah, that's why I'm avoiding
giving me the answer.
Yes, because I'm just maybe as
okay. That's about between 20 and 25 years, I think.
Between
20 and 25 years.
Okay. Okay. So you are fairly experienced police officer, and very senior also in rank.
Yes, Madam Chair, I think so. But we all learn. All of us learn something new each day.
Yes. Yes. I just want to take issue with you on some of the issues that you testified about, but I want to avoid getting into a debate about your views, your opinions, the inferences that you draw, because as an experienced police officer, you will agree with me that your responsibility is merely to collect the evidence. Am I correct? And present it to the prosecution.
That is correct, Chair, but when the prosecution is not doing their job, it's also my responsibility to do something about that also.
Yes, but I'm saying your primary role is to collect the evidence, and in the course of collecting your evidence, you will obviously take witness statements. If there are real evidence, like a knife, for instance, which is associated with the commission of the offense, you will also have to, seize that particular article.
That is correct, Madam Chair.
So, perhaps maybe before I come to that particular issue, one of the issues that you complained about was that when the charges were withdrawn against, when Advocate Mokgoro withdrew the charges, he never consulted with you. Am I correct?
Well, I wouldn't call it a complaint. I'm just mentioning the fact that he didn't, and I would have expected him to do so. If he wanted an overview or an objective and a more broad sense of what happened.
If it's not a complaint, what is it?
If you want to see it's a complaint, if you want to see it as a complaint, then it is a complaint. I'm just saying to you, I'm stating the facts. That is what I felt at the time.
If you don't consider it to be a complaint, what do you consider it to be?
Madam Chair, it's something that I thought needed to be done. It wasn't done. And I pointed it out.
But you will agree with me that in terms of the relevant legislation, the head of the Special Commercial Crimes Unit is only obliged to consult with the DPP of the relevant division.
I do not disagree with that, but what I do have an issue with, and if you want to call it a complaint, if he sees the representations of the suspects / accused in the matter, and he does not speak to the other party involved, which would be the South African Police Service, then I have an issue with that. Bear in mind that he doesn't have to speak to me, and I agree with that.
No, I'm not talking about speaking, I'm talking about consultation.
The same, yes, I agree with that.
He doesn't have to consult with you?
No, he doesn't.
Okay. Let's leave that issue, because now we are at one that he need not have consulted with you. Let's come to the second issue, the issue of interference. And I guess the previous issues that I raised with you regarding the fact that you don't draw inferences as a police officer relates to this very same issue that I'm now going to take it up with you. Accept inferences that you draw, accept your views. In other words, accept the documents that are before us upon which you draw an inference of an interference, or accept your views. Is there any factual basis upon which you base your allegation that Advocate Mokgoro interfered in the investigations against Mdluli?
I would like to answer the question. If you could be more specific, are you talking about general interference, or are you talking about specific interference?
Okay, let me put it this way. Maybe then maybe we'll come to the heart of the issue. You mentioned in your testimony that Advocate Mokgoro interfered in the investigation. Am I correct?
I can't remember the exact words, but that is what it boils down to, yes, Madam Chair.
So what you're saying is he interfered in the investigation related to Mdluli?
I'm saying that the decisions that he has made it very difficult for us to investigate the matter because of the views that he held at the time.
Yes.
And I'm still struggling to curtail those views.
So in essence, what you are saying is the interference is related to the decision that he made.
And
Am I correct?
And the subsequent letters that he wrote. You will remember the first memorandum where he said that regardless whether there's a case or not, whether there's a case or not, the investigation cannot continue. And then he followed it up with saying that the investigation is finalized. He also said at some stage that there's a problem with how the documents were confiscated and with the interference there. So those are the things that he said in communication, letters, memos.
Yes, but
that all interfered in the investigation, as I testified earlier.
Yeah.
I am still struggling to, I'm still being accused of stealing the documents.
Yes.
Because of what he said.
Yes. Let me put it this way. Because when I refer to a factual basis amounting to interference, I just want to give you an example. If you give a prosecutor a docket to make a decision, and you later retrieve the docket and you find that an essential document is missing from the docket, which was in the possession of the prosecutor, that's an example I'm talking about. A factual allegation relating to what he has done, not your inferences drawn from the documents which are before the hearing, because the hearing can make its own inferences. You understand?
I do understand, and that isn't the only way in which one would interfere in an investigation. There are various other ways. And from where I sit and what I've experienced, what Mr. Mokgoro did, he interfered in the investigation. He tried to stop the investigation. If that is not interference, then I don't know what is interference.
Well, I put it to you that you've got no factual basis for that particular allegation. It's merely the inferences that you draw from the documents which are before us.
Madam Chair, if someone tells me a case is closed, or it doesn't, or this doesn't fall within our mandate, or the various other statements he made, if that does not tell me, and that's not an inference, that he does not want me to investigate the matter, then I don't know what he's telling me that. Because that is exactly what it says. The matter is closed.
Well, my colleague has dealt with that particular issue when he was cross-examining one of the witnesses, and in particular about that particular issue. So I don't want to revisit it. Safe to say that he has never said the case itself is closed.
I don't agree with that. That is not true.
Now, like I said, I do not want to deal exhaustively with issues relating to inferences and views, because otherwise everybody has a view and which differ from one person to another person. So I just want to deal with a different issue. The next issue is in your evidence, you are saying that one Lazarus who faces similar charges as Richard Mudluli has been or is being prosecuted.
That is correct, Madam Chair.
What are you trying to convey by that statement if you say, well, Lazarus is on trial facing the same charges which Mudluli ought to have faced?
No, that is not what I said, Madam Chair. I said it was a spin-off of the investigation that we did. So it's separate charges, separate incidents than the one relating to Mr. Barnett and Mr. Madluli.
Did I make a mistake or did I misunderstand you? Because I thought you were trying, and you can correct me, I thought you were trying to say to the inquiry, look, Lazarus faces similar charges, and despite the fact that, despite the fact of the issue of declassification, his trial proceeded, but Advocate Mokgoro decided to withdraw the charges. I thought you were drawing that parallel. Was I wrong? If I was wrong, I would be happy to leave it and proceed with.
Chair, there wasn't a parallel that I wished to draw, but now that you mention it, you will also know that Advocate Nell, who dealt with the case, does not fall under the behest of Advocate Mokgoro. He falls under, at the time, under Advocate Msinyati, the DPP. Therefore, there was no, I see it from where I sit, there was no impediment for the case to go forward.
But as an now that you say it was a parallel that you wished to draw, but surely, Colonel Ruloff say, as an experienced detective, you should know that each case will depend. It will depend on its own merits. In other words, it will depend on the investigation which has been done by the relevant investigating officer and the information that has been acquired up to the stage when the prosecution places the matter on the roll. It's not just about the fact that it relates to the secret account. Not, sir?
Chair, maybe I misunderstood. If you can just break that down to me.
Okay. For you, what I'm saying is, you cannot draw that parallel because each case will have to depend on its own merits.
So just to point out something out, you drew the parallel, not me. I just comment on that.
Okay.
That's the first thing. The second thing is, yes, that is true, but the same information, the same circumstances prevailed in both these cases. In other words, it was about crime intelligence, it was about the Secret Service's account, and it was about operatives of the Secret Service of Crime Intelligence. So the circumstances in terms of that were the same. And according to Mr. Mokgoro, I cannot investigate that because it is part of a situation which I can't investigate because it falls within in the hands of the IG as he stated at the time.
Now if you say you didn't draw a parallel, but didn't you own it up subsequently after I had mentioned it?
Well,
or are you saying I don't want to talk about the issue of a parallel because that's not what I said. Let's agree because I raised it for clarification and you said you didn't, but then you said, well, now that you mention it, yes, I can draw a parallel. Now I just want to know, what are you saying? Are you saying I didn't draw it, so leave it? Or,
no,
or what are you saying?
No, I'm not saying leave it because that is a very good example as to what happened there. I think if that specific matter still fell under the auspices of SCCU, I would not have been able to continue with that investigation either.
My next question in this regard then will be, who was the investigating officer in the matter of rule of sin? Sorry. I'm sorry. Lazarus.
It would have been me.
Lazarus.
That is correct, Chair.
Okay, so you investigated both Lazarus and Mdluli.
That is correct, Chair.
Now, I can see that if you investigated both of them and the decision to prosecute Lazarus, who took that decision?
I would imagine it would be, it is in the office of Advocate Mzinyati, but the prosecutor involved was Advocate Nell.
Advocate Nell. I'm not going to deal with you in regard to the decision to prosecute because Advocate Hofmeyer will be coming this afternoon, and I'm going to deal extensively with him in terms of the decision to place the matter on the roll. But all that I want to put it to you is the fact that, and this is what I would later on take with Advocate Hofmeyer, that look, all that you do as a prosecutor is simply to decide on the matter, on the docket that you have received, whether to prosecute or not to prosecute, and those decisions differ from one prosecutor to another prosecutor.
Madam Chair, that is true, but in this specific instance, there was a decision to inform SAPS to stop the investigation. That is what I'm trying to get over to this inquiry, because it was in no uncertain terms and clear from the communication that we have received, I have received upon request from the NPA to review Mr. Mokgoro's decision, that he was not going to review it, and that he decided that the case is closed. I cannot see any other thing than he is telling me, we must stop the investigation.
But the substance of the allegations in the Lazarus matter are obviously not the same as in the Mdluli matter. It's not the same allegations.
I testified to that earlier. It's not the same, but it deals with exactly the same issues. It deals with CI, it deals with secret documentation, it deals with the Secret Services account, and it is the same in the sense that Mr. Lazarus and Barnett were accused of receiving a benefit, not in a similar transaction, but something to that effect.
I'm at the conclusion of my cross-examination, I'll revert to this particular issue to demonstrate to you that the Mdluli matter was never ready on the 5th of December 2011 and is still not ready now when I do my conclusions.
Madam Chair, that is not correct. On the 5th of February, December 2011, the matter was finalized. Investigation, and now I will agree with you, an investigation per se is never finished until you are in court and the evidence are presented. They can always crop something up. That I agree with you. But as far as that case being court ready and trial ready, it was. And there was nothing impeding on that. That is why the decision that was made was not based on whether there was merit to the case or not. It was based on what the accused and the suspects told him, that this is a secret environment and that SAPS cannot investigate the matter, and he stopped it. That is the bottom line.
Well, we will revert to that particular issue. Maybe let me just, as a preface to my following questions, just deal in details with the role of the SAPS, the NPA, and the judiciary. As an experienced detective, would you agree with me that this is what I put to you earlier on, to say that the SAPS would investigate a crime, open a docket, and after opening a docket, put it before a control prosecutor or somebody to make a decision? Am I correct thus far?
That is, in general, that is correct. But as I testified, I think in the beginning, I said that the cases that not only myself but other individuals are involved with are sometimes very high profile, and there is a prosecutor gets appointed to do those cases. In other words, there's a much closer working relationship between just taking your docket to the court, to the magistrate's court, leaving it there for the decision and coming back. There is a much closer relationship between the investigating officer and the prosecutor in those kind of matters, because of the sensitivity, because of the media attention, because of all those details regarding that a specific case.
In regard to those cases that you are alluding to, what is actually the role of the prosecutor?
The prosecutor is always there to decide whether he's going to prosecute or not.
Okay. So, what you're saying is we have cases where you can simply give the docket to the prosecutor for him to or her to make a decision, but you have other cases where they will be guided by there will be cases which are guided by the prosecutor. The prosecutor will guide the police in the investigation of the case.
Madam Chair, maybe I should just be more specific. I worked in the environment of the ACTT, the Anti-Corruption Task Team, and it was a working method where we worked together with other departments, like AFU and just the NPA. And various other departments. So it was a collaboration between those departments. So in that is what I'm saying is that, you know, we work much closer with the prosecutors in these kind of matters than your normal detective at station level.
No, I understand what you are saying, and I accept what you're saying. But if I take it further, then I will say, for that matter to be actually enrolled, that is now the decision of the prosecutor.
That is correct, Madam Chair, but as I also said earlier, in those kind of circumstances, those kind of cases, we as in the course of that decision, we get consulted, we get talked to regarding those kind of decisions. Because of those cases, because of the enormity of those cases.
I do not dispute. I know that in the course of the happenings in the regional court, the magistrate court, commercial crime courts, you will always find an investigating officer trying to persuade the prosecutor or assist the prosecutor in showing the prosecutor that, look, you might be missing this document. This matter is complete. This matter is ready to be placed on the roll because of 1, 2, 3. I do not dispute that happens. But what I'm saying is, ultimately, when a decision is made to place that matter on the roll, it is actually the prosecutor who does that.
And as I said earlier, Madam Chair, I do not dispute that. That is true.
And I don't know whether you know this, but I'm just going to put it to you, and you can comment if you want to. And the reason for that is simply because if anything happens after the matter has been placed on the roll, in other words, if there is some kind of an allegation of malicious prosecution, it is not the police who are in trouble, it's the NPA which is in trouble. I just put it to you.
Well, I'm not in a position to answer the question, okay, because I haven't got a clue in terms of the malicious prosecutions you are referring to. If it's in general, yes, I presume so, but not in this matter.
No, I'm just talking in general, the role of the prosecutor and the police, just trying to distinguish them before coming to this particular case.
As a matter of course, that would be the issue. That would be how it is supposed to happen. Yes.
Yes. And then after that is placed on the roll, it's up to the presiding officer or the court to determine the guilt or innocence of that particular individual.
Yeah, during the trial.
And you say this matter was ready on the 5th of December 2011. It was ready for trial.
That is correct, Madam Chair. It's not on the 5th, it would have been earlier than that, because we are referring to the memo of Advocate Mokgoro. So the docket was done before that time.
Yeah. So what you're saying is, although the investigation was not fully completed, but it was done in such a manner that it could have been proceeded with on trial. In other words, when the matter was withdrawn, on that date, it could have been postponed for trial.
I do not understand the comment that you made regarding the fully completed. As I stated earlier, investigation is never fully completed. You always would want to have more information. So as far as I'm concerned, at that point in time, the investigation was done and it was enough for us to go on a prosecution.
Mm-hmm. Can I just... Can I just refer you to page 185 of the bundle with Are you there?
Is this the memo from Advocate Mashimiti?
Yes, yes.
Yes.
Before I deal with this issue, can I just say that Can I just say, as you can see on page 185, this is a memo from Advocate Masha Maite, dated the 27th of November 2012.
That is correct, Madam Chair.
To M. Mokgoro. Do you see that?
That is correct, Madam Chair.
Is it true that when you say that the matter was ready for trial, we are only referring to the corruption or fraud issue relating to the motor vehicles?
That is correct, Chair. At that point in time, the other information was still coming in. We didn't have all of it.
Yes. So all these issues that I'm going to raise with you is going to relate only to the motor vehicles. I'm not going to deal with a trip to, is it China or Singapore?
That's fine.
Okay.
That's fine.
Okay. If you can flip over to page 190. Are you there?
Are you
there?
Thank you. I'm here. Thank you, Madam Chair.
You will see that on page 190, at the top there, it says possible charges against Lieutenant General Mdluli, Head of CI, and Colonel Barnett, Supply Chain Management. You see that?
I see that, Madam Chair.
And there is paragraph 1 talks about fraud or theft, and paragraph 2 it's also fraud or theft.
That is correct, Chair.
And on page 191, 3 it's corruption.
That is correct, Madam Chair.
You agree that this relates to the motor vehicles?
That is, well, I presume so. Yes, I agree, Madam Chair.
Let's just read under 3. It says, can you just read under paragraph, under corruption in the amount of 48,303.01 loan by Atlantis Nissan? What does the prosecutor say there?
We need to determine whether Madluli influenced and or gained the loan in a corrupt manner, in particular when he said to Mr. Venter that he will take care of him in the future.
Does it sound like the prosecutor is happy that the matter is ready for trial?
Well, I cannot speak on behalf of the prosecutor, but I mean, there was a loan agreement in the docket which was in his possession. It was a service provided to the SAPs. I really do not understand his comment there. And thirdly, SAP sold about, or CI sold about 61 million rands worth of vehicles, bought 61 million rands worth of vehicles from that company. So it is a clear service provider, and it's an arrangement that is not supposed to be there.
Well,
and Mr. Madluli is in charge of crime intelligence who's buying these vehicles.
Well, my question related to the memo of the prosecutor, where you have just read the comment.
Yes, I did.
Yeah, I put it to you that just by reading that particular paragraph, definitely it shows that the prosecutor was not happy that the matter could be placed on the roll.
Well, I do not agree with that, because the prosecutors in December 2011 was happy that the matter be placed on the roll.
Let's go over to page 199. You see there, it's a memo again from Advocate Mashamaite to Advocate Mokgoro on the 28th of March 2013, the following year. You see that?
I see that, Madam Chair.
And on page 200, phase 1 of the investigation, you can see the bold letters on page 200. It relates to the motor vehicles.
That is correct, Madam Chair.
On the issue of the investigation by the prosecutor, I just want to draw your attention to page 206. I think the inquiry the panel members can go through these documents. I don't have to deal with each and every page. If you go through to page 206, you look at the bold letter, the bolding there. It says on page 206, it says, the question, therefore, is whether Barnard committed an offense by agreeing that the 12,303 over allowance be paid to reduce the shortfall on the BMW 7 Series belonging to Mdluli, considering that the aforesaid amount was paid at the discretion of the dealership based on their relationship with client Barnard. There is further no evidence that BMW Leo Heise stroke Mr. Fesser was forced to pay this amount to reduce the shortfall on the BMW series. This payment looks like a business decision deal made by the dealership in order to conclude the deal with client Barnard. You see what the prosecutor says there?
I see what the prosecutor says.
You don't certainly agree with what
no, I don't disagree. I don't agree with him. Yes. It cannot be.
Yes. But he's the prosecutor. You are the detective.
That is correct, but I'm still entitled to disagree.
Yes, you're entitled.
Thank you.
But the final decision is that of the prosecutor.
Yes, but this wasn't the issue at the time, Madam Chair.
Let's flip over to page 208.
Sorry, was it the issue at the time when Mr. Mokgoro made the decision, and did he base that decision on this statement? I'm trying to understand the line of questioning.
Advocate Moroka, the issue is when the charges were withdrawn, the Advocate Mokgoro had problems with the fact that firstly, there was no case. There was no case against Richard Mdluli in the docket.
Based on the level of investigations at the time.
Yes. And further also, he also had a problem in relation to the admissibility of the documents, which ought to be obtained by the police, because those documents were not there. So this exercise for me is merely to illustrate to this experienced detective that, well, the decision makers in the National Prosecuting Authority, even a year after the charges were withdrawn, were still of the view that this matter cannot be placed on the roll.
And the witness says he disagrees.
Yes. I just want to go through that particular process. Thank you.
Go ahead.
Colonel Rule Officer, we are at page 208. It's a memorandum from Advocate Mashamaite again to Makhatle on the 22nd of May 2013. And on page 209, phase 1 of the investigation relates to the motor vehicles. See that?
I see that, Madam Chair.
I just want to read to you on page 211, the second paragraph that starts with Mr. Venter and the last paragraph thereof. It says, Mr. Venter's evidence is therefore crucial to confirm whether there was a loan between him and Mdluli, or whether the documents purported to be loan agreements with Mdluli were just disguised. Mr. Venter must also explain why he paid the 48,203,001 to BMW Leon Hesse to cover the shortfall on Mdluli's BMW 7 Series. And in conclusion, in that paragraph dealing with the motor vehicles, it says, it is therefore my submission that the evidence of both Mr. Fesser and Mr. Venter is crucial in taking this phase of investigation forward. And this phase relates to the motor vehicles.
Madam Chair, I have not seen these memos before, so it's the first time I've seen them. And I can only go back to what was in the docket at the time. These things were all in the docket at the time. The information that is relayed here were in the docket at the time. It wasn't as if it wasn't there. So, as I said earlier...
Sorry, Mr. Rudolph, I think we...
Can you kindly just repeat your concern regarding the docket? Yeah.
I said that the information, I'm not talking about what is written here. I'm saying that the basic information regarding the transaction and how it unfolded was in the docket at the time. It wasn't as if it wasn't there. These things were subsequent issues that were raised by the prosecutor in order, I presume, to make the case stronger. I'm not sure. As I said, this wasn't discussed with me. I don't know about these memos. But at the time, the transaction, the basic transaction, and how it unfolded was in the docket for consideration. And I go back to my earlier statement saying that from where I sat and when I read those memos, this wasn't a concern for Mr. Mokgoro. The issue was not this. The issue was the fact that we got involved in investigations where we should not have gotten involved in.
So, the additional information that you say you are not aware of, when did that become part of?
I'm not exactly sure what
don't know.
additional information it is,
Yeah.
because as the investigation unfolded, Mr. Venter came forward in the sense that he told us he was told what to say in the affidavit which he provided to us at the time. And he was told by members from crime intelligence what to say. So his affidavit changed, and he testified to that in open court not too long ago, because he was influenced to say certain things which weren't true. So in fact, that made the case actually stronger in respect of this specific matter. But it wasn't known at the time in 2011, in December. It came to light afterwards, after Mr. Venter went to speak to his lawyer, and this information came to light.
Thank you.
Maybe before I proceed with my the exercise that I was doing, maybe let me just take you on something, perhaps just to clarify an issue that you are, which ought to be better placed on the record. In summary, what would you say were the allegations against Richard Mundluli, just in summary, relating to the motor vehicles?
It is
the essential allegations.
Him receiving a benefit.
He received a benefit from?
He received a benefit from a service provider.
A service provider.
And he also received, and together with that, there's a transaction where money that was supposed to go to the state, what you call it, a deduction.
Discount.
A discount. That was supposed to go to the state in terms of the vehicles that they bought, went to the to offset his the amount of money he still owed on his vehicle.
I just want to deal with one aspect, just to demonstrate to you that just one issue. So the crime intelligence would have bought motor vehicles, 2 BMWs, from this particular dealer.
That is correct, Madam Chair.
Okay. Now, you would agree with me that for crime intelligence to purchase 2 motor vehicles, somebody from within crime intelligence would have had to authorize the purchase of these 2 motor vehicles.
That is correct, Madam Chair.
And I know you are not a prosecutor, but you are saying the matter was ready. So let me ask you the question. If you can't answer, you tell us so. It would have been necessary to allege in a charge sheet that that crime intelligence had authorized the purchase of the 2 motor vehicles before we come to the issue of the benefit.
With all due respect, Madam Chair, that was part of the vehicle file that was provided to us by the dealership. All the invoices, all the documents that was raised in respect of the payment of this vehicle coming from UTE, or crime intelligence, was in those dealer files. So it wasn't as if it wasn't there, it was there, and it showed payment. We had the money trail.
But with due respect, Colonel Rule Officer, you are actually not addressing my question. Should I remind you what my question is?
Yeah, if you could, please.
Thank you. I will do so. My question was, and it's a very brief question. My question was, for one of the allegations that ought or should have been made or would have been made would have been the fact that crime intelligence authorized the purchase of 2 motor vehicles from that particular dealership.
Sir, and Madam Chair, and as I answered, the documentation to prove that was in the dealer file.
Sorry, can I just interject here? You premised your question by saying you know he's not a prosecutor. But then you go on to ask him, why was that not raised in the charge sheet? How is he supposed to know why a submission or why a particular submission is not made in the charge sheet by a prosecutor? I mean, this is a difficult question that you're putting to him and expect him to answer, but you've premised it and said he's not a prosecutor. but you want him to give you an answer on the decision that could have been made by a prosecutor?
Well, the question is not very difficult because, with due respect, he hasn't said the question is difficult, firstly. And secondly, the issue here relates to the investigation of this particular issue. And as a detective of more than 20 years' experience, surely an issue as simple as an authorization by crime intelligence for the purchase of motor vehicles, if I say that document ought to have been there, it should be easy for him to answer.
I don't think that was the issue, or that was the question. The question that is posed by my co-panelist is whether that question that you're asking him, or what you're putting to him, is appropriate, not whether it is easy. Is it an appropriate question to ask, knowing that he is not a prosecutor? Preceding your question was a statement that you know that he is not a prosecutor, but you expect him to respond to a question as if he was the prosecutor in the particular matter.
Well, Madam
Whether
Chair,
the question was easy or not is besides the point.
Well, Madam Chair, his evidence, the high water mark of his evidence in relation to the withdrawal of the charges is that this matter was ready to go on trial.
That was his view. That was his view, and you have already distinguished the view of the prosecutor as opposed to his view. And I thought that was settled. But now you want him to respond to a statement or a question which is expected to be asked of the prosecutor. How is he supposed to know? And that's what my panelist is saying.
Can I just take some instruction? Madam Chair, now that I am made to understand that we sort of agree that this witness is not a prosecutor and cannot express an opinion on issues relating to whether prosecution should have ensued, I'm going to leave that issue for argument.
Thank you.
Thank you. Colonel Rulofse, I don't want to go through all these memos because they say almost the same thing, and I'm talking about the fact that the prosecution was not ready, even after even some month or 2 years after 2011. So I'm just going to deal with the last memo on this particular issue. But there are others, but I'm just going to deal with the last one. The last one that I want to deal with on this particular issue is the one on 241. You see that?
I see that, Madam Chair.
Now, this is now a different prosecutor now. It's C.M. Viljoen.
That is correct, Madam Chair.
But to the same advocate, M. Mokgoro.
That is correct, Madam Chair.
If you flip over to phase 1, if you flip over to page 242, you will see phase 1 of the investigation relates to the motor vehicles. Do you see that?
I see the heading. That's correct, Madam Chair.
I just want to read to you what Advocate Viljoen says. He says on page 242 at the bottom, he says, any discussion about this phase of the investigation will be mere speculation. It is impossible without a proper A1 statement to even suggest a way forward. By the way, what is an A1 statement?
It will normally be the first statement in a police docket.
Okay.
Most of the time it's from a complainant.
Yes. So based on these reports or memoranda by the various prosecutors who are seized with the powers to make decisions to prosecute, I put it to you that even the matter was withdrawn in December 2011, and even in 2013, according to these reports, this matter was not ready to be placed on the roll. I put it to you that way.
Madam Chair, that's not correct. The matter in total was not ready to place on the roll. And this is, you must read this in context. At this point in time, you can see Advocate Viljoen had not consulted with the witness. So she's not making she's not saying anything. She said she needs to consult with the witness. And at this point in time, we already knew what happened, and there was interference with the actual witness. So you need to put it into context.
Can I find out? Page 242. Was there an A1 statement in the docket?
Yes, there will always be a A1 statement in the docket, but I cannot remember in this regard which was the A1 statement. It might have been a document that we see somewhere. I'm not exactly sure. I can't remember.
And then it says, the paragraph about that, the chief investigator rule officer, is it referring to you?
I would presume so, Madam Chair.
Is in Pretoria this week in an attempt to sort this out. What are they talking about?
It was trying to get Mr. Venter and Advocate Gaum with Ms. Venter or Ms. Viljoen to sit down for a consultation to take place.
Did you have statements of these people in the file in December?
Yes, they were in the docket in December. But as I said, Mr. Venter's statement, not Mr. Visser, but Mr. Venter's statement, he provided an additional statement later on saying that he was influenced to say certain things in his first statement. So it made it worse for the suspects or accused in the matter.
And then you mentioned something about he revised the statement and gave evidence in the case. Which case are you talking about?
I'm talking about the Lazarus case because Mr. Venter also gave evidence there. That's why I'm saying that this is an intertwined investigation.
Thank you. Can I refer you to page 262 of this bundle? You will see that it's a memo from Advocate Mokgoro to Mr. Ngasana. You see that?
I have that in front of me, Madam Chair.
And you'll also see that it's dated the 14th of July, 2014.
That is correct, Madam Chair.
Can we go over to page 281 of the same memorandum? And let's look at paragraph 245. This is what this is what Advocate Mokgoro says. Another meeting was also held in my office on 5th October 2012 with the investigator of the matter, Colonel Rulofse, and his supervisor, Brigadier Mudli, where problems relating to the matter were discussed with them, and during which occasion I specifically made a proposal that they must consider using Colonel Barnard, the co-accused of Mdluli, as a possible Section 204 witness against Mdluli. I do not know what subsequently happened out of that proposal. Do you recall that meeting?
I do recall the meeting, Madam Chair.
Do you recall that Advocate Mokgoro proposed that or rather, it should be considered that Colonel Barnard should be used as a possible Section 204 witness against Mdluli?
Madam Chair, this is news to me. I had the meeting with him. The meeting was held because I requested the meeting with him. And the meeting related to the fact as to what had happened and why is this case not in the court roll. I wanted to know from Mr. Mokgoro as to why he made the decision that he made. That was the reason for the meeting. The fact about Mr. Barnard being a possible 204 witness, that was raised long before Advocate Mokgoro had this discussion with me, or this meeting that we held. So it was not something that he has raised as if it was his decision or his moment of clarity. That is not what happened there. What I'm saying to you is that this meeting was held to find out why he made the decision he made, not because of the shortcomings of the investigation.
Are you saying there was previous discussions relating to the use of Colonel Barnard as a 204 witness?
I'm saying right from the start there was a discussion for the possible use of him as a 204 witness, but that is prevalent on him if he's going to accept that or not. That had nothing to do with Advocate Mokgoro. That was part of the discussions between me and the prosecutors at the time. So,
well, I put it to you that on this particular date there was such a discussion.
Madam Chair, it was long ago. I cannot say that I remember every sentence in that conversation, but I cannot remember him saying that he is proposing that we use Barnard as a 204 witness, a Section 204 witness in that matter. As I said to you, the reason why I went to see him is not, he didn't call for this meeting, I called for it. It's because we wanted to find out as to why he made the decision that he made.
Are you saying you cannot remember, or are you saying that he never said it on that particular day?
It's a difficult question. As I said to you, I cannot remember each and every word. I'm not saying that Barnard didn't come up, but I cannot remember that he said this in this context regarding Mr. Barnard. That I don't remember.
So therefore, you cannot deny when he says that he raised this issue with you on that particular date.
I can deny that he raised the issue about Section 204. He did not mention that Mr. Barnard must become a 204.
Well, then I don't really understand you, because on the one hand you say you don't remember every word of it, but then you say that he didn't say it.
No, Madam Chair, that's not what I'm saying. I'm saying I cannot remember whether the question of Mr. Barnard came up, or whether the name Barnard was used during the conversation. What I'm saying is that the issue about him being a 204, that did not come up during the conversation. I would have remembered that.
Now, it's February 2019, and this matter was withdrawn in December 2011, and you are saying the charges in respect of the motor vehicles were ready in 2011.
That is correct, Madam Chair.
Are you aware that Advocate Mokgoro was removed from the matter in July 2014?
I'm not aware.
July 2014, again, if I calculate it, it will be July 2014, 15, 16, 17, 18. It's more than 3 years that he has been removed from the matter. It's 3 years now.
Are you asking me to comment?
Yes.
That might be it, but we still, I still sit with the legacy of what Mr. Mokgoro did in respect of his earlier decisions.
And the legacy that you talk about is simply just withdrawing a matter.
No, it is about me still struggling to get the matter on the roll, to convince people that that the matter is supposed to be on the roll and that we didn't steal any documentation. In other words, the struggles that we are facing now is twofold. It is because of what happened with the initial decision by Mr. Mokgoro, as well as SAP's reluctance to declassify the documents.
Sure, you give Advocate Mokgoro some kind of supernatural powers. I mean, he's removed from the matter in July 2014. He's no longer dealing with the matter.
And why am I being asked or accused in January this year that still being accused that I stole the documents? So I'm saying to you that the legacy of what has happened, transpired at that time, I'm still dealing with that.
And Mr. Advocate Mokgoro was also away from the NPA from July 2015 until he returned on the 16th of July 2018. That is when his name was struck from the role of advocates. So from July 2015 to July 2018, he was not in the NPA.
Madam Chair, my answer stays the same. I'm talking about the legacy of what he's left behind in terms of his memos and his decisions that he's made.
Do you know whether there were people who came after Advocate Mokgoro, you know, when he was no longer there dealing with the matter or when he was suspended? Do you know whether there were people who dealt with this particular matter?
Yes, there were 3 or 4 prosecutors appointed by, I think, the NDPP advocate Nixana.
Yes.
And after that, a proper and a comprehensive charge sheet was drawn up.
Yes. And the matter was placed on the roll.
The matter was again placed on the roll, that is correct, as per the decision of the, I think there was the SCA.
Yes. And what happened?
It happened that the matter was again stuck off the roll because of the police not declassifying the documents.
Yes. The same problem that Advocate Mokgoro had in 2011.
No, sir. I think we're getting confused at this point in time. At that point in time, there was no declassification of documents in that docket at that time. That issue became an issue afterwards, after we received the additional information.
I don't think you could ever say anything good about Advocate Mokgoro, can you?
Sir, I don't know the man. I have met him once. It's not a question of saying something good about Advocate Mokgoro or not. It is his conduct in terms of this specific investigation. He might have done a lot of good things in respect of other investigations, but I'm talking about this one. I have not had the pleasure of dealing with him in terms of other investigations.
I just want to, on this aspect, I just want to close up by referring you to an incident in your affidavit. Just to illustrate to you that it appears to me that you can never say anything good about Advocate Mokgoro. So can we just go to page 281?
281?
Yes.
Which bundle is that now?
Is the bundle of containing your unsigned affidavit? Are you there?
Yes, I am there.
I just want to draw your attention to paragraph 41, where you say, remember, I prefaced, before reading this by saying that I don't think you can ever say anything good about Advocate Mokgoro. So let me read the paragraph. You say here, in addition to all the above, I was also informed that Mokgoro used his position to try and influence another matter. I spoke to Advocate Nati Mncube there is a cellular number there from the National Prosecuting Authority. Even though I'm not familiar with the allegations made by Mncube, I do not wish to repeat the allegations. I would, however, deem it necessary that whoever investigates this matter includes that into his or her investigation, as it is clear from the allegations that this kind of conduct by Mokgoro is not an isolated incident. You don't know the nature of the issue related to Advocate Nati Mncube, do you?
Madam Chair, if you read the sentence, even though I am now familiar with the allegations made.
What are the
allegations? Was that Advocate Mokgoro interfered in a search and seizure, that he phoned a police officer on the scene where the search and seizure took place, and requested or told him to stop the search and seizure. And I cannot remember more than that. That is why I put this in this affidavit, so that the investigating officer in this matter can speak to him and deal with Mr. Mncube directly.
Do you know what happened to the allegations? Do you know whether these allegations ever went to court?
No, I don't. That's what I'm saying. I don't know what happened. I informed the investigating officer as part of my affidavit.
Yes. Now let me put it. Let me tell you what happened, and then you will see why I say that it appears to me you are seriously prejudiced against Advocate Mokgoro. The allegations contained in this paragraph relates to the allegations that Advocate Mokgoro had contravened the provisions of Section 32 of the National Prosecuting Authority Act. Those were the allegations.
And
the material allegations were almost to the effect that you have alluded to. And he appeared in court, and what happened in court was, this is what I'm putting to you. He appeared in court, a decision was made by the National Prosecuting Authority, National Director of Public Prosecution, Mr. Ngasana, to have him prosecuted. He appeared in court, and when he appeared in court, something very comical happened. In court, the senior advocate appearing for the state indicated to the presiding magistrate that he wants a postponement on the basis that they want to, that the national director wishes to brief an external counsel. And in this instance, and that external counsel was Advocate Barry Roux, to decide on whether there was a prima facie case. You wouldn't know about this.
I would not know, Madam Chair.
I put it to you, it was comical because the national director had made a decision. He came to court. When his senior advocate was in court, he informs the magistrate that he wants to outsource his decision to an external counsel. And the magistrate refused, and the matter was struck off the roll. That's how comical it was.
But he doesn't know all of those things. Why do you expect him to have a view on things that he doesn't know? He says he doesn't know.
Yes, but Madam Chair, he has made references to allegations related to Nathi Ngube. And he says that somehow those allegations have a bearing or relevance in these proceedings. And we say, as far as those allegations are concerned, because there is nobody that we can put to, because he's the one who's doing this.
In the situations that you are describing to him, he says over and over, I don't know.
Yes.
Yeah.
Well, yes, I've just been advised, you know, to put it this way, that, you know, when we put these issues to him, and these are not issues that we pluck from the air. These are issues that are in his affidavit. Now, because they are in his affidavit, this we put it to demonstrate that when he says in his affidavit that these issues demonstrate a pattern of interference, we demonstrate that these are factually baseless.
But he has answered you in regard to what he knew and what he said.
Yes.
You can't expect him to answer on issues or questions that he doesn't know of, as you did.
Well, I'm leaving it there, Chair, because clearly he has also conceded that he knows very little about the issues surrounding Advocate Ngube. So I'm not going to...
I think you can't reasonably take it further with his responses up to now regarding what you expect him to know and what he says he doesn't know.
Well, I was just putting to him, not expecting him to know anything, because just putting to him that this is the true position, so that the evidence leader...
It's already answered the question.
Yes, yes.
Anyway.
Can I just confer with my colleague, because I've come to the end of my cross-examination. Just want to know. Thank you. May we just have 10 minutes adjournment so that I can take proper instructions?
Can we adjourn for 10 minutes? Thank you.
I can make. I have closed the matter. That is what he said.
Well, I'm not taking further because I noticed that you have just agreed with me that you are drawing an inference, but I'm not taking further. The last issue that I want to deal with you is the issue about the fact that you say that you are being accused of stealing, what, dockets or a docket?
No, that's not what I'm saying. I'm saying that up until this point, there is within SAPS a portion of people that believes that we stole the documents. Now, that is just an argument for not declassifying the documents from where I sit. Now, that argument comes from right in the beginning when Mr. Mokgoro, based on the representations and the meetings he held with the suspects in this matter. That was based there, and we are still struggling to convince SAPS that it didn't happen that way.
So the allegations that the allegations that you stole documents or docket is made within SAPS.
What I'm saying, Madam Chair, it was made within SAPS. What I'm also saying is that it is a consequence of the decision that Advocate Mokgoro made at that time, where he stated that that there's an issue with this and that we obtained the documents illegally.
But you are not saying it was Advocate Mokgoro who accuses you of stealing documents or docket.
Madam Chair, that is what he said in his memos. He didn't use the word steal. I obtained it illegally. There's many ways of obtaining something illegally, but you write this memo, and it becomes in the public domain. Members within SAPS, especially CI, sees it. They need a reason not to declassify the documents, and this is being used as a reason not to declassify documents. I'm still sitting with that legacy.
I put it to you that the reason why this matter has never been placed on the roll, it's simply because it was not properly investigated from the beginning.
Well, Madam Chair, I must disagree strongly with that. I think there is enough senior advocates that went through the docket at the time and afterwards that does not hold that view. I can only base my answer on that.
I've got no further questions.
Thank you, Mr. Ramawela. Are we ready for re-examination? Ms. Bauer?
I am. Can you hear me?
We can hear you clearly.
Yes, I can hear you, Advocate Bauer.
Okay. I want you to go back to your affidavit of the 8th of January, paragraph 48, which was referred to in cross-examination by Mr. Majavu.
I'm sorry, which paragraph is it?
It's 48.
Paragraph 48.
Yes, of the affidavit of the 8th of January.
Yes, I have it in front of me.
Right. And the proposition that was put to you was that you had formed an impression that the person who was on the plane was Advocate Jiba. And for the sake of clarification, could you just clarify precisely what was the information at your disposal which led you to the belief that the person on the plane was Advocate Jiba?
Madam Chair, what had happened is I have, and this is where I'm unclear, but this is normally what happened, is this specific witness, the Section 204 witness, which I alluded to earlier in my testimony, that he would come because I questioned him and I had interviews with him over a long period of time. He would start to remember things. So now, what I cannot remember is whether I told him I saw a name of the National Prosecuting Authority on the passenger, not the passenger list, the passenger list from the company, or whether he said to me that there was a prosecutor from the NPA on a flight with Mdluli. Or whether I mentioned Jiba and he said, yes, I know, but Jiba was also, not Jiba, that Mdluli was also on the flight and was a high-ranking, was NPA official. So I can't remember exactly how that came forward, but based on what he told me, I investigated and I found that Mdluli was there, and I also, in terms of the passenger manifest, I was able to conclude that Jiba was on the flight, on Nkombo Jiba was on the flight, and I also knew that there was only one from my questions at NPA, that there's only one Nkombo Jiba. So based on that, I made an inference, I made a conclusion. I concluded that it can only be Advocate Jiba. Or that it is Advocate Jiba that was on the flight. Subsequent to that, with my further inquiry at Department of Home Affairs, it just enforced the belief that I had it was Advocate Jiba that was on the flight.
Now, you were presented with a Voyager number that Advocate Jiba provided from her purse on Friday. It is so that the only difference in the number which is contained in your affidavit and the one she provided is that the last digit was a 9, whereas hers was a 7. Is that correct?
That is correct, Madam Chair.
And do you accept that you could have made a mistake?
Yes, I could have made a mistake. That is why that is why, in terms of the original affidavit that I've supplied, the actual documentation would have been attached to that.
Right. And that is the documentation that docket is missing.
That is correct, Madam Chair.
Right. Now, the person who is said to have, in your investigations of Westfield and One Stop Travel, right? Do you know who the author of the documents were that was generated on which the name Nomkoba Jiba appeared?
Madam Chair, the one person would have been the travel agent who received the initial request, and the second person would have been the travel agent that did the actual booking. So those two would have been the authors of the name, and they would have written down what they thought, how the name was spelled.
And you confirmed that in your investigation?
That is correct, Madam Chair.
Okay, thanks. I now want to move on to the questions which was asked by you this morning of Advocate Ramaili. In your 20-somewhat years,
Advocate
as
Ms. Bauer.
As a detective,
Ms. Bauer.
is it? Do you find it strange that a high-profile case is withdrawn without any reference to you?
She can see just to this.
Yeah. Ms. Bauer.
Sorry, did you hear that?
Yeah. The name of counsel is Mr. Ramawele. Ramawele.
Yes, that's correct. Yes, yes. And
We apologize profusely for this.
Even the pronunciation is perfect.
Thank you. Did you get that, Ms. Bauer? Mr. Ramawele.
So,
The correct
Mr.
Ramawele.
Sorry, Madam Chair, you do not come over very clearly, but I think I get the gist of what you're saying.
Yes. So kindly, let's pronounce the name correctly. Thank you. You can proceed.
Can I continue?
You may proceed. Yes. Yes. Yes, Ms.
Okay.
Bauer.
I think the sign language is working much better.
I think we'll relay our sign
my
language
learned-
through rule officer. Okay.
My learned colleague posed certain questions to you in cross-examination. I want to raise a few questions in respect thereof. And the first one relates to whether in your 24 years of experience, high-profile cases are withdrawn without reference to the investigating officer.
Madam Chair, I have not experienced that before. As I said, the ACTT, the whole makeup of the ACTT was of such that the various entities collaborate and work together. So that would be part of that whole process of how we deal with things within the ACTT mandate, because there was various entities working together. So it just follows that you would talk to each other and consult with each other when you make these kind of decisions.
The example was given to you of interference in relation to documents being removed by a docket. But isn't it so that in this case that doesn't arise because Advocate Mokgoro was not given the docket?
Well, initially he said he didn't get the docket, but I mean afterwards he actually, as from my understanding, he did get the docket. So, but that didn't arise. There was no issue like that in this specific matter.
Has it ever been suggested to you by any of the prosecution or SAPs that the prosecution of General Mluli was a malicious prosecution?
No, Madam Chair, never. The only people that suggested that was the accused and the suspects themselves.
Now, a number of reports were read out to you from prosecutors that were appointed during 2012 predominantly. Were you consulted by those prosecutors in relation to the preparation of those reports?
No, Madam Chair, I was not. I was consulted in terms of the investigation, but I wasn't consulted in terms of the preparation of those reports.
Okay. So before they gave their opinion, they didn't get your opinion?
I can't say in every instance, because I know that we did discuss the cases, but what is in the memos is news to me. I wasn't aware of those memos and what it contained.
Right. And on the last allegation that was, no, that's fine. I don't need to deal with that. Thank you, Colonel Rolfsa. I don't have any further questions.
Thank you, Madam Chair.
Thank you, Ms. Bauer. Mr. Blau. The message is still being transmitted. Should be okay.
She can do this on our behalf. Oh.
Can we, I think
unplug us just
possibly
like that.
Advocate Bauer will hear me if I speak
Yes.
through these mics, but Advocate Bauer, the chair, was thanking you.
Thank you. The choir master doesn't work well over Skype.
To relay our sign language messages. Oh, she's off? Okay. But thank you so much, Mr.
Thank you.
Rulofse.
Thank you, Madam Chair.
We really do appreciate your willingness to come and assist the inquiry.
Thank you, Madam Chair. I
It is
appreciate it.
much appreciated.
Thank you.
Ja, thank you. Nee, ons het dit laaste keer gesê, nee, dat ons dit heel wat waardeer. No, I think they do appreciate it. I mean, there's nothing as valuable as testing evidence. And it's an opportunity that anybody would value highly. Okay, thank you so much. Yeah. Just a minute, Mr. Rulofse. Mr. Majavu wants to say something.
Thank you, Judge. Just arising from what my learned friend, Ms. Vilagazi, had to say in relation to correcting certain impressions in the media. I think, to be fair to Colonel Rulofse, there is just one aspect that I want to converse with him, purely for avoidance of doubt. Because what had happened on or about Friday afternoon, there was a huge poster which referred in definitive terms to Advocate Jiba as a spy of the NPA. And in the spirit of the rules of engagement, Judge, that you had laid right at the beginning, I did not want an impression to be created that it arose or was as a consequence of his testimony on Friday, because you would recollect that that was one of the first issues that we got out of the way. And to the extent that it may or may not be ascribed to Colonel Rulofse, I wanted to place on record that I did not gain an impression that he had said that. In fact, to the contrary, he disputed that notion. It is something that I'm also taking with the Ombudsman, because there are serious consequences in our culture and for historical reasons for one to be labeled as a spy. And to be fair to Colonel Rulofse, I just wanted to confirm with him that that is not what his evidence was, and we just leave it at that. I'm not making an issue out of it, but I think it's only fair for him and also to protect my client's interest. Thanks, Judge. I take it no higher than that.
Thank you so much for that, Mr. Majavu, and the inquiry appreciates the fact that you reminded us about that and the way you handled it. Okay? Thank you so much. As you have heard for yourself, Mr. Rulofse, I think the inquiry appreciates it. Okay?
Thank you. Thank you, Madam Chair.
You may now stand down.
Thank you.
Thank you.
Thank you, Madam Chair. If we may just adjourn for 5 minutes. The next witness is here, and I just want to make sure he's brought his counsel with him, and can we just make arrangements to move on to him?
I've been asked never to accept proposals for a 5-minute break. We make it 10 minutes. Okay.
Thank
if
you,
you are
Madam
ready
Chair.
before 10 minutes, then it's fine.
We'll
Thank
do
you.
that.
Thank you. Good afternoon, everybody. We have some AC issues, air condition issues. You hear the noise from the aircon. Apparently it's competing with our voices and the recording. It is possible to lower the speed and even the aircon, whatever, and it's going to become hot as a result. I remember in the beginning we had permitted people to take off their jackets, you know, if you need. Yes, Mr. Masuku, you're right. So let's take off our jackets if needs be and find a way of lowering that noise, okay? But can the camera people or whoever feels that the noise is competing with our voices, not by themselves, handle the air conditioner? Let those people who know how to do it, do it. Let's try to avoid resolving our aircon issues by ourselves and ask for assistance, because only those people know how to do it so that it doesn't disturb the recording. Okay? Yes. Thank you. Take off your jacket. You may, if you feel it is too hot for you. Okay? Oh, starting with you. Absolutely. Yeah, you have very good reason why you should take off your jacket. Yeah. Okay. Yeah. And then our choir master has been asked to please remind all of us that we need to speak up and try to speak into the mic. Two things: we speak up and we speak into the mic in order to mitigate all of these issues. Okay? Yes. Mr. Hofmeyer, you've heard that we kindly ask you to speak up and speak into the mic, just to deal with the gentleness of your voice. Okay, thank you. Ms. Butlender, can you just let us know where we are?
Yes, thank you, Chair. Advocate Bauer is going to be involved in this part of the proceedings from Cape Town, but I believe there's still cross-examination to begin with.
Mr. Hofmeyer, can you hear me?
Can hear you clearly.
Thank you.
Ms. Manda, our witness is still under oath. No? You don't have to administer the oath again.
Yes, you are being reminded that you are still under oath.
Thank you.
I also understood that our witness is still under cross-examination. So can Ms. Bauer explain or request, or with your leave, tell us why she is now interposing the witness at this stage when he's under cross-examination?
I had asked Ms. Butlender to let us know where we are,
I'm
so
sorry,
that we know how to proceed.
I didn't mean that she was interposing. We're waiting for you to resume your cross-examination, is what I should have
okay.
said.
So you may proceed then.
Sorry, if I was mistaken, I apologize.
Yeah,
But if,
no, it's all right.
Because we did spend quite a bit of time, almost 2 hours, waiting for documents. And one of the documents, or perhaps all of them, were apparently made available by Mr. Hofmeyer. And again, we find this quite extraordinary that a witness who should or ought to be aware of the rules of cross-examination has now brought additional documents to the inquiry, and more so an affidavit which is from a George Frederick Hardiker, and it would appear, well, firstly, we assume that this Hardiker will be called to come and give evidence before this inquiry. But we also find it quite disturbing that whilst under cross-examination and is represented by his lawyer, Mr. Hardiker said at paragraph 3 that this affidavit was compiled following Hofmeyer contacting me. And then in the same paragraph, in the last line, even though he says he no longer works for the NPA, he's been duly authorized by Hofmeyer to depose to this affidavit. Does he now work for Hofmeyer, or did he get some authorization to depose to this affidavit? Perhaps Ms. Ba or Ms. Budlander, Raja Budlander, can explain to us where this fits into the scheme of things.
Ms. Budlander, would you respond to the question?
Thank you, Chair. Yes. Let me start with the two issues that Mr. Arendse raises. The first is the additional documents that Mr. Hofmeyer brought today. Those documents we hadn't had sight of before he brought it, and I assume he wants to refer to it in cross-examination. I'll let him deal with that. That's not our documents. All of our documents are placed on the Dropbox, as you know, as evidence before the Commission. In respect of Mr. Hardaker's affidavit, Mr. Hardaker's affidavit is different. It has been on the Dropbox since Friday. It's not something that Mr. Hofmeyer has brought here. It is, Mr. Hardaker has given evidence like all of the other affidavits that are on the Dropbox. I consulted with him approximately 10 days ago as part of determining whether to put this evidence on the Dropbox. At this point, we hadn't planned on calling him as a witness, but should that be necessary, we can discuss that. The plan was simply to put it on the Dropbox, which is what we did on Friday. And I'm not sure whether Mr. Hofmeyer plans to use it during his cross-examination, but we would be entitled to use it during re-examination because it's on the Dropbox and it's evidence before the Commission. I'm not sure if that answers the concern.
Well, as far as the Hardaker affidavit, I was surprised that the delay was due amongst others. I was surprised that the delay of this afternoon was due to, amongst others, that affidavit, but when on the Hardaker affidavit we received on Monday. Today is Tuesday, that was yesterday. So we had sight of that document. So we were surprised that proceedings might be stalled because of that affidavit. And obviously because we only received it yesterday, on just a plain reading of the English, it would appear that this affidavit was sourced or solicited by Mr. Hofmeyer. It would have helped had we been told that actually the affidavit was sourced by the evidence leaders. The other documents are minutes of meetings that have been made available, NPA, I think executive committee meetings that have been made available to us.
Just to respond to the Hardaker question, Chair, the Hardaker affidavit was placed on the Dropbox on Friday, but there was an error in the email that was sent to the parties. Generally what we do is we place it on the Dropbox and email parties immediately. There was an error and we realized on Monday morning that email hadn't gone through, even though the affidavit was there. So that's why you received an email on Monday morning. So for that we take responsibility and we apologize for that. And today you have a copy, just for ease of reference, the team printed a hard copy of the Hardaker affidavit. So I think while it may have got handed to you as part of the Hofmeyer documents, it's not part of the Hofmeyer documents. It's always been on the Dropbox from Friday.
Madam Chair,
What's your position
with
regard to...
If we may proceed.
Oh, okay. Thank you. You may proceed.
Thank you, Madam Chair. Mr. Hofmeyer, just to round off on a point towards the end of your cross-examination the last time, you'll recall that I had put it to you, and this is in relation to the Herinel Celebi matter, that Ms. Jiba had been, your evidence, she had been suspended and subsequently was hauled before DC. I mentioned to you that she had approached the Labour Court. I hope I did, if you can confirm that. So for the record, Madam Chair, we've got copies available to the witness and the evidence leaders and the panel. If we could just make available the court order that was obtained by Ms. Jiba on the 17th of June 2009. The court order is in the form of a rule naizai that the respondents, that's the National Director of Public Prosecutions and the Minister of Justice and Constitutional Development, must show cause, calling on them to show cause on the 29th of October 2009, or soon thereafter as the matter may be heard, that they are interdicted and prohibited from continuing with the disciplinary hearing scheduled for the 18th of June 2009 or any date thereafter, pending the hearing and finalization of the unfair labor practice dispute lodged by the applicant with the Labour Court involving the alleged violation of the provisions of the Protected Disclosures Act. So my first question to Mr. Hofmeyr is just whether he was aware of this, or does he confirm also that that was his understanding, that the matter was subsequently settled, and that settlement notice of withdrawal is also part of that small pack of documents. The withdrawal was on the 18th of September 2009.
Chair, I am aware of the settlement at the time. It did come as as far as my knowledge was, this did come as a surprise to the NPA as a whole. Our understanding at the time was that this was a settlement reached with the Minister of Justice rather than with the NDPP.
So, to the extent that the notice of withdrawal also cites the NDPP as the first respondent and the Minister as the second respondent, is it your evidence that this settlement agreement was only reached between Ms. Jiba and the Minister and not the NDPP? Or are you saying that the NDPP, to the extent that the NDPP was involved, didn't have any authority to enter into a settlement agreement?
I mean, this is many years ago, so my memory may be a little bit hazy, but my recollection is very much that this came as a surprise to the NPA, the settlement. It is possible that the then National Director was aware of this proposed settlement, but he hadn't shared that information with the rest of his top management.
Who would the NDPP then have been in September 2009?
It was Mr. Mshe.
Mshe. But one can assume safely, I suppose, that the NDPP would be authorized to enter into settlements of this nature.
I assume so, but normally, okay. It is a bit complicated because the NDPP is not normally vested with the administrative powers.
That still falls under the DG.
under the DG, and then it was at the time many of those powers were delegated to the CEO of the NPA.
Is there, so you were surprised, according to your evidence. Did you raise it subsequently anywhere in any forum?
I did make some inquiries, but I can't say that I got a conclusive answer of who was involved in the settlement. So it was not a high priority for us. It was a fact that we had to deal with it.
So fast forward to December 2011, I think, when Ms. Jiba is appointed as the acting NDPP, an appointment which, if I recall your evidence in chief, you welcomed. She was going to be a breath of fresh air. You were quite complimentary about her managerial, administrative abilities, convening meetings, sort of all-inclusive approach, consultative approach, I think.
But if I can just clarify, I can't say I was happy about her appointment at the time, but in the way that she conducted herself, those comments apply.
You were pleasantly
it was
surprised.
a bit, yeah, after the appointment.
I take it you didn't have any difficulty with Ms. Jiba's qualifications for the job otherwise at that time?
I did have a reservation about her very rapid elevation from being a deputy director to becoming a deputy national director. I think that was fairly unprecedented in the NPA at that time, that somebody would get such a rapid promotion.
Yes, I also questioned Ms. Breitenbach on this.
Sorry, Mr. Arendse, just make it go nearer, yes. And don't swallow your words at the end.
I apologize.
Yes, Ms. Breitenbach also seemed to be surprised. And I put to her what I'm going to put to you now, because it surprises me, and I would submit also the panel and everyone in this room. Ms. Jiba had been a prosecutor since 1988.
I believe so.
So by 2011, she had some 12, 20 odd years of experience in the prosecutorial services in various positions?
That's correct, as did many hundreds of other prosecutors have that much experience.
Unlike you when you were first appointed to the NPA. You weren't a prosecutor at all, you were a public interest lawyer.
That's correct, but I think I was appointed because of the expertise I had in the area of asset forfeiture. By the time I was appointed, only 2 asset forfeiture cases had been done in the whole country. I think one by Shamila Batoy and one by And when Mr. Nguka was appointed, he was keen to use the tool of asset forfeiture, so he approached me on the basis of my technical skills and proficiency in asset forfeiture rather than in prosecutions.
So there always seem to be exceptions to the rule. You don't have to be a prosecutor.
I accept that, and in the early days of the NPA, who hadn't been prosecutors up to that time.
Including Mr. Nguka himself?
Including Mr. Nguka himself. But I think what did happen as well during that period is that there were a few rather disastrous appointments made. So I think subsequently when Mr. Nguka looked to make appointments, he by and large went for people from inside the NPA to promote rather than relying on outside appointments. I'm not saying there were a few appointments, but essentially I think he realized that bringing somebody into the organization that had little or no experience in prosecutions particularly was sometimes a recipe for disaster.
But as late as October 2013, when Mr. Kasana was appointed, he also had no experience.
Indeed, and I think it was a surprise. He did have he was a criminal attorney, so he had fairly extensive experience in criminal law. But I think it was a surprise to all of us when he was appointed.
Yes, and neither with Mr. Pakoli, a prosecutor, when he was appointed.
Indeed, he did have, at the time, extensive experience at the Department of Justice, who has, as you are aware, considerable oversight and so on at... let me rephrase that because I'm not sure he was appointed from having been in the Department of Justice previously. I think he was.
I just wanted a simple answer that none of the persons that I mentioned, some of them I count amongst my comrades, were prosecutors when they were appointed. And I'm contrasting this with the appointment of Ms. Jiba, who had been a prosecutor for 21, 22 years, served the organization at various levels.
And she's already had some serious disciplinary issues by that time.
You never raised them at the time. You welcomed her. You were pleasantly surprised by the way she conducted herself.
I was pleasantly surprised because of the history with which she came when she was appointed.
Okay.
And I will repeat that in general, in terms of her managerial skills, she was good. Unfortunately, those skills weren't always used for good purposes, but in that way, we had a pretty good working relationship until some of the big issues started happening.
We're going to look at those big issues. Now, before we go any further, and hopefully we won't waste any time, the issues that we are concerned with are 4 matters involving judicial criticism of Ms. Jiba. Is that right?
Maybe you should just mention them to me.
Are you not aware of it?
I am aware, I'm just not sure which 4 you are referring to.
Well, there are 4 judgments. There's the judgment of 23 September 2013 by Judge Murphy. That's in the Richard Mludli matter. Then there's the subsequent SCA judgment of Brandt J.A., retired, of 14 April 2014. Then there's the Gorvin judgment of 20 February 2014. And then there's the so-called spy tapes judgment of 28 August 2014. A judgment you familiar with?
Indeed.
And which we'll look at closely. Now, can we get this out of the way so that we can focus on what's relevant and what's important? You have no personal knowledge, you had no personal or direct or indirect involvement in the Mludli matter or the Booysen matter. Is that right?
It's correct to some extent that I was excluded from any dealing with those cases, unlike the previous practice in the NPA. But the prosecutors and other persons involved in those cases did come and talk to me about their concerns and what was happening in the case. In addition, we were also involved had started working on an asset forfeiture application in relation to crime intelligence, and I think we obtained orders against two of the less senior people in crime intelligence. I became fairly quickly familiar with some of the issues around Mr. Mdluli and the investigation.
There's clearly a difference between becoming familiar with the issues and being directly involved in a matter so that you can, on a first-hand basis, assist the panel in arriving at important findings, recommendations, and conclusions. Do you accept that?
I do accept that, but as I say, some of the things that were going wrong in these cases were brought to my attention by Ms. Breitenbach and others at the time.
But do you accept
They came to me for advice. They told me what was happening in some detail. So in that way, I was not unaware of what was happening in the cases.
But you experience enough to know, Mr. Hofmeyer, that I can't cross-examine you on what Ms. Breitenbach told you or any one of the other persons who may or may not have been directly involved, what they told you.
Indeed.
You accepted the veracity and the say-so of what Ms. Breitenbach told you or what Mr. Ferreira told you or any one of the other prosecutors working on the case may have told you. I can't cross-examine you on what they told you.
And we did also, some of these issues were discussed at NPA meetings in which all of us were present, including myself. But I had, and I saw some of the evidence myself at the time. I was not only relying on what I was being told by the people in charge of the prosecution.
I showed you, and if needs be, I'll show it to you again. I showed you a memorandum that was prepared by Advocate Mosing for Ms. Jiba's approval. I showed that to you the last time. Do you want me to show it again?
I think I still have it before me, but I'm just waiting for it to switch on.
Is that where we got stuck the last time? And you saw the report. You saw the recommendation from Advocate Mosing, which was then subsequently approved by Ms. Jiba.
I did not see Mr. Mosing's report at the time. I saw it later.
Well, I showed it to you the last time you testified. And I asked you, in the circumstances, was it wrong? Was it unreasonable? Was it unethical for Ms. Jiba to approve a recommendation made by one of her top priority to crime prosecutors?
I have a number of concerns that I had at the time. I think the first one I mentioned in my evidence last time,
sorry,
which was that the persons who normally comprise the full organized crime desk and normally worked together to approve racketeering authorizations were excluded from the process at that time. I have gone through a range of the meetings of the EXCO of the NPA after our discussion, after the questions you asked me last time. And indeed, questions about that decision were raised in a significant number of EXCO meetings. I'm happy to take you through some of the discussions in those EXCO meetings. But it was an issue of controversy, not just about Ms. Jiba, but about Mr. Chauke as well, who played an important role in that decision. It appeared later.
Yes, for example, he mentions here at paragraph 8. I hope we talking about the same memorandum. Where is it? Where is it on the drop-off? Eh? On the drop-off.
Is it an affidavit or a memorandum?
We're just finding it. Because I had it out the last time. But just while my colleague Advocate Masook was finding it, in your extensive experience at the NPA, there must have been many controversial decisions taken by the National Director of Public Prosecutions, or even by directors of public prosecutions, which were not always the subject of some kind of agreement or consensus in the office?
I wouldn't say many, but there were a significant number.
And they would tend to be the more controversial cases, isn't it?
There have not been a huge number of decisions that were taken on judicial review and overturned. I think that is the difference that we are talking about here, is that, for example, that decision was taken on the judicial review. A court found that things went or were significantly wrong in the process.
Including the matter that you were involved in, the spy tapes matter, where you had differed with the prosecutors in the case, and you and Mr. Mshe took a decision against their wishes, and that decision went horribly wrong and was overturned.
I should correct you that I didn't take any decisions. I made a recommendation to Mr. Mshe about the decision. I've also looked carefully at the judgment of the court, and I was advised by my legal team that no findings were made. Despite the criticism, there were no findings made in the judgment against me.
We're going to look at it, Mr. Hofmeyer, because the criticisms leveled at you in particular make any criticism of Ms. Jiba pale in comparison. I can assure you when I read them back to you. In fact, you went according to the judgment, not my judgment, the judgment of the SCA. You even attempted to interfere in the prosecution of the case. You attempted to change prosecutorial memoranda that was submitted to you and to Mr. Mshe.
Chair, if I can maybe just ask, is it possible for us to finish the issues around the Booysen prosecution? I'm happy to move on to this, but
I'm going to move on to it. You've raised it as an issue. I've asked you, or I put it to you, one, I submitted or suggested to you that as a matter of course, you as prosecutors in the NPA, and I'm obviously making a general statement, would disagree from time to time on a particular prosecution or a decision to prosecute or not to prosecute. And you said yes, sometimes, but not all the time. And then I suggested to you, well, especially in the more controversial cases, there would be differences of opinion. And I think you accepted that. But then you highlighted this particular case of Mludli that had gone to court and had been, or Booysen, that had been reviewed successfully in court. So you placed it in issue, and I, in our closer home, said, but you were involved in a matter that had gone horribly wrong and had been overturned by the courts. That is where we are now.
Sorry, Chair. I can see that Advocate Bauer is trying to speak. Can we just check the sound, please?
Where's the motion?
Advocate
Ms.
Arends.
Bauer? Ms. Bauer? You want
Can
to
you hear me,
interject?
Madam Chair?
You want to interject? You seem like
I
you want
do.
to say
I think
something. Yes.
Advocate Arends, sir, was a question about the prosecutorial memorandum relating to Advocate Mossing, where the memorandum was he shoots questions. And I think the witness asked him, can we first please finish the Booysen matter before you go on to another issue? If I understood it correctly, Advocate Hofmeyer, or Mr. Hofmeyer, wasn't finished with what he had to say about.
I think we might want to leave him so that we see what the line of questioning is all about before we make an intervention. It might be a way of linking issues. Let's just see how far he goes.
Madam Chair, before this exchange between myself and Mr. Hofmeyer, I asked him whether we could somehow limit my questioning of him by agreeing that he, because he was not directly involved in Booysen or Mludli, that I should rather not ask him any questions because he's not able to be of assistance to us, to this panel. I'm not sure whether I can say that he did, or he did with a qualification, where he said, but he also learned more about what happened in both those cases by interacting with other colleagues. And I then said, well, but I can't question him on what these other colleagues had told him. And then he went on to say, but there were also, he also heard and knows about the matter through various meetings that were held. And then I had asked him about the memorandum, which I don't know, my colleagues are still can't seem to find on the Dropbox, that Advocate Mosing had placed before Advocate Jiba, making a recommendation which she accepted, and I asked him, in his opinion, was it unreasonable or wrong or even unethical for her to have accepted Mosing's recommendation. And he was beginning to describe why he had his reservations about that memorandum and or decision. Some people had been removed from the decision-making process. And I think I'm summing up the...
I think the chair agrees with you that you go ahead.
Yeah.
I'm not sure why you are going backwards to explain. She said
I'm actually responding to Ms. Bauer's interjection.
But she's ruled. She's ruled that you can go ahead.
I've said we'd like to see, let you go ahead so that we can see the connection that you might,
Did you not find it?
this line of questioning might need to,
Yeah. So,
or is
and then,
being shown to.
so I think
drawn.
I think Mr. Hoffman fairly summarized the exchange that we've had up to this point. But I said to him, but you were involved in a matter directly, and that is the spy tapes matter. Because he raised the issue that Ms. Jiba was involved in matters that were subsequent, that went horribly wrong, and that was subsequent.
You can proceed with your question.
So Mr. Hoffman, let me put it to you this way. I don't think it's going to serve any purpose. It's going to benefit anybody if I cross-examine you on either the Booysen matter or the Mludli matter. Because quite frankly, you're unable to assist us there because you were not directly involved in the matter and you have no direct experience or evidence that you can put before the panel.
Chair, I disagree. I was in a significant number of meetings where the Booysen's matter was discussed in some detail. I was part of a small group that was asked by Mr. Ngasana to look at the circumstances around that racketeering authorization and the prosecution. So I have a significant amount of detail about and personal knowledge about what happened in that case, and I would like to talk to that before we move on to another topic, or alternatively we can return to it at a later time. But I think that is very, very relevant to what we're talking here.
So do you accept what is very, very relevant, as you say at this stage, is that the Govan decision was in effect reviewed by two judges in the GCB application against Jiba, the judgments of Justices Lachodi and Hughes, and that was then approved subsequently.
Sorry, Mr. Arons, is that a correct legal exposition of what happened? The judges in Gauteng reviewed the Natal judgment.
I think now we have difficulty hearing you.
For a change,
Yeah.
I was trying to understand the proposition that you put into the witness, that this was a review of Govan's judgment. Was that what it was?
I said effectively. I interposed it with the word effectively. Of course it wasn't.
Okay.
In fact, they make it clear that it wasn't. Yes, but let me put it this way.
That's also what you should make the witness understand.
Can we, because I summarized this with General Booysen the other day. The decision of Govan J did not absolve General Booysen of any guilt. The decision of Govan J didn't say that the NPA could not revisit the issue of authorizing racketeering charges in the future. What the Govan decision said was there wasn't a rational connection between the decision made to proceed with the racketeering charges and the information that was available at hand to Ms. Jiba at the time. That was, and there was a criticism of Ms. Jiba, and I took Mr. Booysen through this, and I was hoping that we didn't have to go through it again, because the information that was before the two judges in the striking off application, Justices Lachodi and Hughes, now dealt with this issue that Ms. Jiba was criticized about. It dealt with it, and I can take you to the passages. The court in that case also analyzed the Section 2.1 authorizations with reference to case law.
Mr. Arons, I'm really very sorry that I'm interrupting you. The difficulty that you and I have is that we are always in the thick of things. Therefore, when you ask a question or you make a proposition, I'm waiting for the question. The difficulty that you place the witness in is that you've made a number of statements, and it's usually better if you cut it up. Otherwise, what question is he going to respond to? If you know what I mean. You've made about 5 propositions. You haven't gotten a response from him. At the end, it doesn't help us nor help you, because I don't know what he's going to be responding to. I'm sorry to be doing that.
With respect, Advocate Moroka, it is because in the first place, you quite rightly pointed out to me that the Lachodi Hughes decision was not a review or didn't overturn the Govan decision. I said, in effect, it did, and I maintain that that's the case. As a matter of legal analysis, that's what it did. I was now, so in order to avoid making such a submission, I tried to explain the difference between the two judgments to the witness. That is what I was trying to do, and then the punchline was going to be that and so more than a question, I was going to put it to Mr. Hofmeyer that Ms. Jeeba's conduct was cleared in relation to the racketeer. The authorization of the racketeering charges was cleared by Justices Lagodi and Hughes, and subsequently that clearance was approved of by 3 judges of the Supreme Court of Appeal. So perhaps he could now comment.
Sorry, Chair. What I would like to comment on is how the internal processes of the NPA appeared to be abused in that matter, and my personal knowledge that I have of how those processes were abused. I think we all accept that decisions taken by the NPA can be overturned by courts afterwards. But I also think we need to be clear about what it is that went wrong, and to the extent that Advocate Jeeba was part of such wrongdoing, that I think that's information that is relevant to be placed before this inquiry.
Mr. Hofmeyer, you would be expected to answer, save if they are unfair or unreasonable, you would be expected to questions that I ask you. You gave your evidence in chief when you were led by Ms. Bauer.
You asked me about the process in the NPA, and I don't think I have completed my answer to your question.
I'm asking you about, I move beyond that because I'm still waiting for this Mosing memorandum or affidavit to be located, and then we can proceed. And I'm afraid you must give evidence. Your lawyer can't assist you in giving answers. That's not the purpose of her sitting next to you.
May I interject at this point, Madam Chair? To be of assistance, I was merely trying to point to where the affidavit may be found. It is in folder J, number 92, is the affidavit of Advocate Mosing, and the paragraph that we were referenced to on Thursday that Mr. Hofmeyer was trying to respond to earlier was paragraph 12, in which he hasn't concluded his response. So if that may assist the inquiry.
Thank you, ma'am. You might want to respond to that.
I'm not going to, ma'am. I'll do so when it suits my convenience. I've moved on.
Do you accept the explanation?
No, I don't. I haven't looked at the reference.
But you need to look at it. She made reference to aspects of the evidence in the document. You could kindly look at it so that we know whether there is need for you or whether you accept it, and you might need to apologize.
Apologize for what, ma'am?
For admonishing her, assisting the witness as she should. She explained what she was doing. She was just pointing the witness to where the evidence that he is supposed to respond to lies. Kindly look at it so that you can decide whether you accept her explanation or not.
Wasn't it? Is this, in which matter is this? I think, yeah.
And if she was not doing what you accused her of doing,
Madam
kindly
Chair,
correct that.
I'm looking for a memorandum that is submitted by the prosecution's team to the NDPP to authorize a racketeering. This is an affidavit. If I have to, then I will. It's no water off my back to do so if I'm wrong. But I'm looking for a member. I don't see this memorandum. This is
Yeah,
an affidavit.
all we're trying to do is to ensure that you are on the same page.
It appears not, ma'am.
Madam Chair, if I may just be of assistance, if cognizance is taken of the record of Thursday, it would establish that the last question posed was based on this affidavit and paragraph 12 thereof, which Mr. Hofmeyer hasn't finished answering yet.
That's what you had asked to be completed first before we move to the Booysen matter.
Let's see, paragraph 12.
You're not able to be of assistance about what we're
Sorry,
looking
Chair,
for.
I've been looking, I'm just not clear what Mr. Arns is looking for. There's a prosecution memo that is done by Advocate Mayema that accompanies a recommendation from Advocate Norco that we referred to yesterday in leading General Booysen. That was the document that I understand served before Advocate Jiba. I'm not sure that there's a prosecution memo by Advocate Mosing that does the same thing. Unless Mr. Arnser refers to Ms. Jiba's affidavit in which she says that various people advised her. That's in the GCB affidavit.
Yeah,
But there's no memo attached that I can think we have on our Dropbox.
In this affidavit, Advocate Mosing says that he drafted a memorandum for the acting NDPP recommending the approval of the applications for authorization of the racketeering, prosecution and centralization the following day being 16 August 2012. On 17 August 2012, JIBA approved the two applications and issued authorization in terms of Section 2.4 of POCA in respect of contraventions of Sections 2.1e and 2.1f of POCA, as well as in terms of Section 111 of Act 51 of 1977, read with Sections 44 and 22.3 of Act 32 of 98.
Mr. Arnser, I don't know if it will help you. It wasn't, that memo was not attached to any of the papers in the Booysen record, which we have on the Dropbox. I've just done another check now. It's not there or in the GCB papers.
I seem to recall that we had that memo. I don't know, Madam Chair, I seem to recall that the last time I had the memorandum available. But I think
considering what Ms. Butlender has indicated just now,
I think we can perhaps agree that in any event is the gist of what I had put to Mr. Hofmeyer, that Ms. Jiba acted on the memorandum that was placed before her before she approved the authorization in terms of Section 2.4.
But then can we agree on what you had accused Mr. Hofmeyer's legal representative of doing, assisting her in a way that she is not entitled to when she was not doing that?
Well, I'll withdraw it, ma'am.
You may proceed.
So what I put to you, Mr. Hofmeyer, was that on the basis of memoranda that was put to the NDPP at the time, Ms. Jiba, she approved the authorization of the racketeering charges, and I asked you whether that conduct was unfair, unreasonable, unlawful, or even unethical. And you then indicated you had your own issues or problems with this, and I think you were now wanting to
say why I say so.
Yes.
So, Chair, if I may proceed, I think there are a number of issues that arose out of that process. So, firstly, there was a pretty extensive process in the so-called organized crime desk of the NPA at the time to approve racketeering authorization. I mean, to make a recommendation about racketeering charges. That desk at various times included Mr. Mamabolo, Johan Krier, Andrea van der Bijl, and Terence Mlanga, and I think somebody else as well. Joni Spies, I think, was part of it. It was, in my experience, and I was at times part of presenting or dealing with racketeering having an interest in the racketeering authorizations, because a lot of the AFU cases involved that. So it is, in my experience, extremely unusual that only one person, who, if I may say with respect, is known to be very close to Ms. Chiba, takes a decision on whether there should be racketeering charges. In terms of the normal process, what one would have expected was for the prosecution team to come to make a presentation to that organized desk panel, to be interrogated on it, to show exactly how each person is linked to the racket, what the evidence is to substantiate that. It's not that you put a report in front of somebody and they just sign it off. And it was very clear in retrospect that those normal criteria that one expects in a racketeering authorization were not met.
Mr. Hofmeyer, are you an expert in evaluating or determining or deciding on racketeering charges, whether they should be prosecuted or not?
I wouldn't call myself an expert, but I was part of a Justice Committee study group that went to the United States to inquire into some detail about how this offense of racketeering worked. And I was part of a small group of 2 or 3 people who were responsible for working with the state law advisors to draft those provisions in the Prevention of Organized Crime Act.
But you're not an expert.
I wouldn't call myself an expert, but the reality is that many people who were experts were excluded from this decision.
Now Mr.
And so that is my one concern. I do have other concerns as well.
Before you move on to your next concern, do you know what the case law is on what is required to be placed before the NDPP, before he or she decides whether to institute racketeering charges?
I wouldn't want to talk about that too much now, because my interest is in the process that was followed.
Mr. Hofmeyer, I'm asking you, you have tended to give evidence here, not as an expert. And I'm asking you what the law is. And you're unable to tell me, because the law is very simple. Those 2 cases they were in fact, one of them was before Govinjay, and the other 2 were considered by Justices Lagodi and Hughes in the striking off application. The cases of De Vries and Chow both decided in the Western Cape High Court. It is sufficient for the prosecutor to place a memorandum before the National Director of Public Prosecutions outlining the nature of these offences before the NDPP makes a decision. And the reason is self-evident, is that the NDPP is not expected to wade through what could be lever arch files which constitute the docket. That is what the law is. And to that extent, Lagodi and Hughes, the judges, found that there was no mala fides on the part of Ms. Jiba when it came to authorizing the racketeering charges against Mr. Booysen. Now I'm asking you Do you accept that ruling, which was then endorsed by the majority in the Supreme Court of Appeal? Or do you still want to contest it?
I think what I'm trying to talk about here is the extent to which the entire process, not just the racketeering decision, deviated from what the normal NPA processes are. And that includes seemingly the appointment of Advocate Chauke, who is the DPP in South Gauteng, to take charge of this prosecution in KZN.
Problem that ever faced the world to resolve the apartheid problem or challenge. And Nelson Mandela bequeathed this way of working to us. And it is for this reason that I say it is part of our DNA. And besides this being part of our DNA, it is a growing trend throughout the world. Throughout the world, when you go to the World Economic Forum, it's all about collaboration, consensus building, working together. And we say this value and this culture could not have found a more fertile ground than here in South Africa, a country where society, communities were just diametrically opposed to one another, where labor was constantly at war with companies, and where government was also constantly at variance, either with labor and what have you. And now we are saying, let us use this important culture to grow this industry together. We undertook this work of building consensus because we recognize the critical importance that mining plays and can still play in shaping the future of our country. To this end, we moved to speed up the finalization of the mining charter and to provide greater clarity on the Mineral and Petroleum Resources Development Bill. And let me immediately, as I talk about this, pay tribute to a number of you who are leaders in the mining industry, for you never gave up. You kept coming forward and raising your concerns, raising your doubts, and raising your frustrations with us. And at times, we tended to listen, but maybe half listened. But now you have our full, undivided attention. We will listen to the concerns that you may have. If you have any, it means now that you don't have any concerns, and I'm grateful for that. Now, many of you came forward, sat down with us, and as soon as the Minister of Mineral Resources was appointed, he made it his task to meet with industry players, to begin to lay the foundation for building this consensus. And by and large,